So, good afternoon, everyone. Thank you for registering. Thank you for joining today's Lunchtime Learn. A bit of a special one today, as we've got a guest speaker who is a little bit busy at the moment, as I'm sure she'll tell everyone about, helping loads of businesses and loads of people deal with lots of the staffing issues they've got at the moment, and furlough and so on. She's one of our employment law partners that we have with MyPeopleClub, so we just wanted to make absolute use of that and bring her onto this session to share some of her amazing expertise. So I'm not going to do too much of the talking. We're going to pass to Nicola in due course. What I do want to say is the information that Nicola is giving will back up a lot of the documents and resources that we've provided as part of MyPeopleClub to the members. There's a whole load of stuff there on lost, on furlough, to help you right now with the issues that you've got. There's some free resources as well on the Facebook group, but there is a wealth of information that members are enjoying and using. So if that's something that you're interested in and you're needing right now, then do have a look at the website, www.mypeopleclub.com. Find out a bit more about the benefits of joining, and we'd love to see you on the inside. So without further ado, I'm going to hand to Chris, who's just going to give a bit more of an intro and context, and then we will hear from Nicola. So enjoy the session. If you have to drop off, don't worry. We've got it recorded and we will be sharing it. So enjoy.
So I'm in HR, and I know a lot of the people joining the call will be in HR or similar fields. So it has been a crazy few weeks for most people, whether you're sort of directing it or being on the receiving end of it. So we just wanted to bring a little bit more calm to it, a little bit more guidance from an employment lawyer rather than just us HR people chatting about it, and just try and muddle through and get some great advice on some of the questions that we've had through. So we've had loads of questions through. We've tried to group them together so that they kind of make sense as we go through it all. If you do have any more questions as we go through, pop them in the chat box. James will try and get to them at the end if we've got time, if we don't run out of time. Cool. So without further ado, introduce Nicola Ihnatowicz from Trowers Hamlins law firm, who are a city centre law firm based in Manchester. Great law firm. Nicola is one of our great employment law partners. She's done the masterclass on 2P for us in My People Club, which is absolutely brilliant. So we've had loads of great feedback on that. So thank you for that. And today she's going to help answer some of your questions on furlough and just generally managing staff through this time. So Nicola, if we could just start please by, just for those who may not have heard of furlough or totally understand it, which would be quite surprising, but just to get that, sort of expertise opinion around what furlough actually is, a bit of an introduction, and then we'll get into our questions.
Thanks very much, Chris. Yes, of course. So what we're talking about is the completely new scheme which the government has put together. It's their job retention scheme, and it's designed to give employers who are affected by coronavirus in any way some protection to enable them to cover some of their employment and staff costs, to allow them to keep employees in employment during this period of great uncertainty. So at the moment it goes from the 1st of March to the 31st of May, but they've said that it might be extended after that. The way it works is that the employer designates an employee as furloughed, which is a form of temporary leave. The employee has to have been on the payroll on the 28th of February. So there are some issues arising out of that, some people falling between the cracks, which we can talk about. When selecting who to furlough, the employer has to be careful not to discriminate or breach any other form of employment law, or otherwise, select unfairly. So again, we can talk about how you do that. The period of furlough has to last at least 3 weeks. And then the employer can claim back 80% of the employee's wage costs, up to a maximum of £2,500 per month per employee. And that's just basic pay. So bonus, commission, or other allowances like car allowance, for example, are excluded. On top of the wage costs, the employer can claim employers' national insurance and their statutory minimum auto-enrolment pension contributions. So that's the 3%. It's open to employers in all sectors. So as long as you had a payroll in the UK as at the 28th of February, you can have access to the scheme. But there is some quite strong guidance for employers with public funding. So local authorities or employers who are providing public sector services, where that funding continues, there's quite strong guidance that their use of the scheme should be the exception rather than the rule. I think the point being that if you're continuing to receive public funding that covers your staff costs, you shouldn't be double recovering some of that by claiming back from HMRC under this scheme.
Yeah.
So that's kind of very brief introduction to some of the key points, but let's get cracking on the questions. I know there are a lot to get through.
Yeah, we've got quite a lot. So just on that, the first question you've touched on there. So furlough lasts for a minimum of 3 weeks. One, is there any leeway in that? Two, does it have to be 3 consecutive weeks, or can you do sort of a week on? Because a lot of people are talking about rotating staff, to try and make it fair, all that sort of stuff. So how can you sort of manage that with your staff?
Okay, so yes, it does have to be a minimum of 3 weeks. If you take an employee off furlough before that 3 weeks is up, then you can't claim any of the costs for the entire 3 week period. Even if it was, on 2 weeks and 5 days, you still, it's got to be the whole 3 weeks. So you can't rotate, 1 week on, 1 week off. But what we think you can do is rotate in blocks of 3 weeks. So, if you don't need to furlough an entire team, for example, if there is some work there to be done, but not as much as there would be in normal circumstances, you could have Team A and Team B and rotate them every 3 weeks.
Okay, brilliant. Okay, so we've done 3 week cycles. When you want to furlough, obviously we know that you need to get their agreement to do that, but after you've got their agreement, do you have to give notice, or can it be immediate? And what do you do if for some reason you can't get agreement?
Yeah, it's a really good question. So the guidance makes clear that there's, they expect that employers will have to get agreement to them being furloughed. The point being that obviously the employee isn't guaranteed their full salary. It's up to the employer whether they top up to 100% or not, or whether they just pay the 80% up to the £2,500 cap. So there's a basic point that it's expected that employees will have to agree to be put on furlough. Once you've got that agreement, though, there's no extra notice requirement. You can do it immediately. Obviously, when you're looking to get agreement, you should be being clear with employees about what you think the dates for their furlough are likely to be, or being clear if you don't know, if it's at least 3 weeks and then until further notice, and we'll keep you updated. So there's no set notice period. It's all for discussion and agreement between the employer and the employee. The added factor for some employers, of course, might be a union relationship. So basically everything that I'm saying is subject to the employer having anything different agreed, either with its trade union or any other enhancement it might have in its policies or its contracts of employment. So those are some other things that you need to have a look out for. But no, once you've got that agreement, you're fine. If you don't get agreement, it's obviously a slightly tricky issue. And for some employees, this could be, obviously this is great as a safety net, and hopefully a lot of people are going to benefit from this protection. But it's still, a potential 20% pay cut or more for employees who earn more than the £2,500 a month. So if you don't get agreement, the employer's got to think quite carefully about what it needs to do next. It still has all of the other cost-saving options that it might have been exploring before this job retention scheme was introduced, or that it might be exploring in normal circumstances. So, that might include redundancy, that might include changes to terms and conditions, that might include periods of unpaid leave, which of course are all going to be subject to negotiation, discussion, policies and procedures, potential consultation requirements as well. In terms of the legal risks, if you impose a period of furlough without the employee's agreement, the employee might be able to resign and claim constructive dismissal, because obviously imposing leave without agreement or imposing a pay cut, that's potentially a fundamental breach of trust and confidence. Whether it is actually a breach is going to depend on how the employer has approached the discussions with the employee. So have they explained why they're being furloughed? Have they explained the alternatives? Have they conducted a proper consultation process in it, for example? So it's not automatically a fundamental breach, but it's a risk. But I think, when you take a step back, is it likely in these circumstances that an employee is going to resign and claim constructive dismissal? I think that's quite a difficult position for any employee to be in at the moment. They might have a technical legal case, but it's quite an unattractive. I mean, one, you've got to resign, so you're out of work in the current climate, which is not a good position to be in at all. It's not like normal circumstances when you might think you'd be able to get another job quite quickly. It's also quite an unattractive argument to make in a tribunal that you're basically saying I resigned because my employer didn't make me redundant, which I think is quite a difficult argument to run. There is also a risk, though, that the employee could claim an unlawful deduction from wages if there isn't a clause in the contract that already allows the employer to do that, to put them on furlough, or, for example, to put them on a temporary layoff. That might give the employer some arguments. So, yeah, they might be able to claim the wages that they're missing out on in those circumstances. So definitely better to have agreement if you can get it.
Yeah, I mean, I was going to say, obviously, it's better to have agreement, but I suppose if you have got that difficult employee for whatever reason, doesn't want, or doesn't agree, like you say, I suppose that it's how much of a commercial risk is it? Because what is the alternative? That they're unpaid, or like you said yourself, it's quite a difficult argument to make later in a tribunal, as long as they've approached it in a fair way and talked to them and all that sort of stuff, isn't it?
Yeah, absolutely. I mean, obviously, the employer's appetite for risk will vary massively from employer to employer, and of course their particular financial circumstances are all going to be different. So I'm seeing some that are quite happy to take the risk because, quite frankly, they can't afford not to. Others who want to take a slightly softer approach. Some who are very concerned about the reputational risks of furloughing if they haven't perhaps thought about all possible alternatives as well, or instead. I just saw this morning on social media that Spurs, the football team, are getting a lot of criticism for not looking at reducing their players' pay when they are looking at cutting pay for and furloughing their cleaners and other support staff first. So that's not a legal issue, but it is a reputational issue. So there is a wider picture for employers as well.
Brilliant, thank you. Okay, so next question. If you've got a limited company and you're both the director or the owner of the company and an employee, can you furlough yourself?
Yeah, it's a really good question. So my understanding, this isn't actually specifically dealt with in the guidance, but I think if you've got someone who has both the role of a statutory director and is also on payroll, you can furlough them from their employed role, and they can still carry on fulfilling their statutory director's duties. So that does mean that they can't do any executive employment function during the period that they're furloughed. So that's something I should have said in the introduction. Being furloughed means that you can't do any work for that employer during the period that you're furloughed. That's fine, that's objective. Obviously, what you want to avoid is any kind of discriminatory criteria, so how you're differentiating between categories of staff. But yeah, actually, I'm seeing a lot of organisations look to try and be, progressive and proportional about how they're, if they've got a little bit extra, to be able to offer that it's going to the lower paid workers rather than the higher paid execs. Yeah.
Okay, brilliant. Okay, so what's recommended in terms of staying in contact with furloughed staff? Because obviously you're not supposed to be doing any work, but can you do training, virtual staff meetings? What have you seen, or what would you recommend? Okay, so you can do training as long as it's not generating revenue for the employer. So that's, I think in most cases, training is going to be fine. Perhaps, and actually it's quite a good way to keep people engaged, because hopefully, when in the medium term, when things go back to normal, you're going to need people back up and at full strength, pretty quickly, we hope. So I think training's fine. Virtual staff meetings, I think not, because that's usually part of your employment role. So except perhaps, maybe social meetings.
yeah, that might be okay. I think in terms of what's good practice, obviously keeping in contact is always good practice. If you think about how you would treat someone who was off on, say, maternity leave for a long period of time out of the business, keeping in contact just, on occasion to let them know what's going on, keep them engaged is a good thing. And especially, I think, if we don't know how long a period of furlough is going to last, so just keeping them up to date about what's going on, touching base about if you're looking to extend the period of furlough or indeed in due course cut it short. If you have got employees rotating through furlough, then again, keeping them up to date about what's going on is going to be really important so that they're back up and running, for their 3 weeks back in the business in due course.
Okay, great. We've had quite a few questions around annual leave. So, can you take annual leave if you're in a period of furlough, or what happens to it? People are worried about, obviously, holidays, sort of building up towards the end of the year or whatever. And also what happens with bank holidays and furlough.
Okay, so can you take annual leave during furlough? This is a bit of a grey area, and unfortunately the case law on annual leave is not massively consistent with the guidance on furloughing. So to be safe, I think it's better not to have annual leave during the period of 3 weeks, because the risk is that you could be challenged and not be able to claim any of the 3 weeks salary costs back from HMRC. But what I think you can do is factor in some annual leave. If you've got period on furlough for a long time, factor in some periods of annual leave into that period. But making sure that each period of furlough is still at least 3 weeks. I think you can do that. Obviously, there's benefit to the employer in the employee using up their annual leave so that you don't have, a socking great load of annual leave built up at the end of the year. And the benefit for the employee because they get full pay for their period of annual leave. So I think that's the safest way to deal with it at the moment, given it's a bit of a grey area. In terms of bank holidays, I think it's just, if there are bank holidays during your period of furlough, there's a bank holiday during your period of furlough. There's no, unless your contract says something else, it doesn't get treated. It doesn't get any special treatment. Okay, so essentially it'd still be at the furlough rate of pay if you normally got double on a bank holiday, all that sort of stuff. Yeah. Okay. As I say, so that is subject to anything particular in the contract. And it might get picked up, I suppose, if your pay varies because you're, say, on double time on a bank holiday, it'll get picked up in your average for the last year. Okay, and just to be clear in what you said just before about holidays and furlough, so you're sort of saying if you need to furlough people for a month, for example, you could furlough them for 3 weeks and then tag a week on holiday at the end of it, so it doesn't sort of invade the furlough period. Exactly, and then the holiday would be at full pay rather than 80%. Okay, brilliant. Okay, so this is a little bit around Martin Lewis, who seems to be pretty popular at the moment. And certainly in some of the big HR groups, he's not so popular. But there's a lot of advice, and I can see where he's coming from, because obviously he is trying to sort of protect the employees or whatever, or say, what you can and can't do in terms of employees. Perhaps not so much from an employer's point of view. But he's sort of saying that, if someone's left after the 28th of Feb and gone to a new job or whatever, then potentially they can come back and ask for their old employer to furlough them, which I believe is an option, but perhaps not always an overly attractive option to the employer, because then obviously if they take them back on the payroll, then they'll be accruing employment rights and holidays and all the rest of it. So what's your kind of understanding or guidance or advice on that? Yeah, so I think what he's putting out there is actually is stretching what's actually allowed under the scheme. So the guidance on the scheme says that if an employer has made redundancies since the 1st of March, because of coronavirus, then they have the option to reinstate the employee and furlough them. So, in other words, if you had businesses that were forced into making redundancies early on in March, before this scheme was announced, before any protection was available, but had they waited, the employee would have been covered by the scheme, then they can reinstate them. There is nothing that says that if you made the redundancies for another reason, so if you made redundancies in February for a different business rationale, there's no obligation on the employer to reinstate those people. And indeed, if you made redundancies for a different reason, you haven't got jobs to reinstate them to. So I don't think that's what the scheme is intended to cover. If you've got someone who's resigned during March for whatever reason, that I think is up to the particular employer. But if you've recruited somebody to fill that vacancy, again, there's no obligation on the employer to to allow the employee to withdraw that resignation or to be reinstated. If they've got work, then they might want to, and they might be able to, no problem. If there's a role there, that's for agreement between the employer and the employee. So I think it is one of the things that's potentially quite harsh about the scheme, is that if you weren't on the payroll on the 28th of February, you're not covered unless you were, if you were redundant subsequently and the employer wants to reinstate you, fine. But that does, it is really unlucky for employees that don't fall on that side of the, that side of the coin.
Yeah, no, that helps clear it up, because there is a lot of chit chat about what it should and shouldn't cover. And like you say, I think the point is that this scheme was introduced because of coronavirus, wasn't it? And it's not really to cover redundancies for other reasons. So
no, and I think if an employer did reinstate in those circumstances to a role that they haven't got, what do you just end up having to remake them redundant at the end of at the end of their period of furlough. So it's, as harsh as it is, it's not in the employer's interest. Morally, I completely get where he's coming from. There will always be people, unfortunately, that fall outside the safety net. So morally, of course, it's awful. But legally, I don't think that's what the scheme was intended to do.
Yeah, no, absolutely. Okay, so next question. There seems to be a bit more talk about shielding in the last sort of week or so, and and vulnerable categories, and we'll just quickly touch on those shortly. But can you just explain a bit more about shielding and what that means?
Yeah, so shielding is for the category of the most vulnerable people in the population. So it's people who are severely at risk if they contract COVID-19. So it's people who are immunosuppressed, such as they've had chemotherapy or they've had an organ transplant, so their immune system is absolutely not at full strength. So those people have been contacted by the NHS to tell them that they're in that category, and they are being told that they need to shield themselves, so for a period of 12 weeks. So that's we're all having to comply with social distancing restrictions and not going out unless we've got a good reason for going out to get food or essentials or medical assistance, for example. People who are shielding can't even do any of that. They have to stay at home. And somebody else is going to have to help them get food, get medical attention, and so on. So people in those categories, if an employer's got someone who's been told that they've got to shield, they can be furloughed. The guidance on the scheme makes clear that an employer can furlough them. Okay,
brilliant. And so this question's from someone who's got a pregnant employee that's due to start maternity leave soon, but will be or is going to be furloughed before the maternity leave starts. How should they manage that? And does it affect any maternity pay, etc.?
Yeah, so once you've got, you can furlough someone before they go on maternity leave, and they can stay furloughed during their maternity leave. They will still be entitled, during their period of furlough, they'll still be entitled to all of their normal statutory maternity pay and benefits, so that doesn't change. They still get that, and the employer, so that's not unaffected. If the employer offers any contractual maternity pay, enhanced maternity pay, they can use the furlough scheme to claim back some of those costs. So that's the way that it would work. If you've got someone who is already on maternity leave, then I think if they would otherwise be at risk of redundancy, were they at work, then again, I think you can furlough them during their maternity leave. It might not make any difference if they're getting statutory benefits anyway, but if you've got someone on maternity leave and in receipt of enhanced benefits, and they would otherwise be furloughed were they at work, then the employer can use the scheme to claim back some of the enhanced costs.
And would that enhanced cost be the 100% of the enhanced cost that the employee would get, or is it still 80%?
I think it's 80%. I think I will double check that.
Okay, no worries. Okay, the next question from that is about childcare, because a lot of people now obviously have got the schools closed, and for businesses that are still open want their staff in potentially, but then they've got childcare issues. So again, a lot of chit chat around whether they should be furloughed or whether they should be unpaid. What's your guidance on that?
Yeah, there's a tricky one. I think this category, there's a kind of category that falls in the middle. So they're not, and this will be people who are affected by, whose working arrangements, whose ability to work is affected by coronavirus or the social distancing restrictions. So I think this covers people who are unable to come to work because they've not got childcare. It could also cover people who are wanting to self-isolate but aren't actually symptomatic or haven't actually been exposed, so not necessarily on sick leave. So there's kind of people in that category caught in the middle. So it's not clear from the guidance whether they're covered by the scheme, but my view is that I think you can furlough them. I think it would, I think it's, that they are people affected by the broader sweep of changes that we're all dealing with because of the pandemic. And if they weren't otherwise protected, their only options might be, unpaid dependence leave or annual leave, or, the employer might have something more generous that it offers. But, in most cases that those options are going to be quite limited. So I think the employer can try to furlough them. As I say, it is a bit of a grey area. So, proceed with caution, but I think it is an option.
Okay, brilliant, thank you. Okay, so self-isolation for yourself. So someone else in the household's got symptoms, only paid for 2 weeks. After this, you'd return to work. If you did not return to work, you'd be absent without pay. Is that correct? So I think this is people that are maybe a bit scared about coming back, or...
Yeah, absolutely. So again, this is subject to the employer having anything more generous in their policies or in their contracts, or indeed, offering anything more generous on a discretionary basis at the moment. So if you've got someone, just to be clear as well, if you've got someone who's self-isolating because they're symptomatic or because they've been exposed to someone who is symptomatic, they should be on sick pay. They should be on sick leave. Once they are better, they can come back to work. If they're not able to do the work, if they're not able to come to work, or if they're not able to do the work remotely, then yes, it's either going to be unpaid leave, annual leave. That's up for negotiation between the employer and the employee. I think it's slightly different if you've got someone who is simply just nervous about coming to work. So they're not in a particularly vulnerable category. There is work for them to do. They're just scared about coming in. That's a slightly different situation. I think the employer probably needs to be live to the fact that there might be a particular vulnerability, not necessarily so serious that the employee has been told to shield, but if they've got an underlying health condition, an autoimmune condition, or a condition like it might be a reasonable adjustment to look at another way of dealing with it. But if you haven't got that and they're just nervous, but there is work that you need them to do, you need to have a look at whether there are, can you comply with the social distancing requirements in the workplace? We're seeing a lot of manufacturers rearrange the
follows on from that. It's the same sort of thing, really. But they've got a lady on maternity. She's due back in a couple of weeks, but sort of said that she doesn't want to return whilst all this is going on. So how do they manage it? Obviously, she can take any holiday, that she's accrued or whatever. But then after that, would it be unpaid leave if she's essentially refusing to come back until it's finished? I know it might be a disciplinary matter as well, but
yeah, that's exactly it. So if there's no underlying health condition, so she's not concerned for a particular health reason, and of course perfectly understandable. It might be because she's got young children at home. That perfectly understandable. But there is work that's there and that needs to be done. And in fact, actually, even if it's if it's a supermarket, they can be classed as key workers, so they can still get childcare. So against the same things, looking at what are the measures in place to try and ensure the safety of the workforce. Then if they really don't want to, unpaid leave, holiday, discretionary leave if the employer offers anything like that, and if not, it's unpaid leave or it's a disciplinary process, unfortunately.
Okay, brilliant. James, we've kind of come to the end of the questions on here, but I know we've picked up, I've been watching the chat go, so I know we've got a few comments and things in there. Should we go through some of those very quickly? We've got about 5 minutes before Nicola needs.
One question we've got, is there a maximum time period or is it up until the end of May currently?
Yes, at the moment, just up until the end of May, and it may be extended after that, so there's no maximum period currently, or just up to the end of May.
So if you've been made redundant and paid, and then you've had an agreement with your employer to be taken back, do you have to pay the redundant back? And will you be made redundant?
So they might want to offset it on the assumption that they're going to have work when the restrictions are lifted. But obviously there are no guarantees at the moment.
And we've kind of covered this, but just to clarify again, it's not 3 months from the date the furlough starts, is it? So it's 3 months until the end of May.
As things stand, yeah.
Okay, let me just see if we've missed any. Bank holidays we've done. So can you clarify the term voluntary work? Do you mean volunteering for another organisation, e.g. a charity, or can you voluntarily do some work for your employer?
No, it's voluntary work for another organisation.
Good try though.
Yeah, nice creative thinking.
So if people have got their annual leave booked through the period of furlough, can they cancel their holiday, or do we make them keep it and pay them for their normal salary?
Yeah, again, good question. The employer is going to need to be live again to making sure that any period of furlough is at least 3 weeks, so that they can claim the salary costs. Otherwise, it's a matter for negotiation between the employer and employees. I'm seeing different employers do different things. So some are very concerned to ensure that they don't have a build-up of annual leave later in the year, so are requiring people to take the annual leave that they've booked, even if they're not going on the holiday that they've planned. I've also seen employers insisting that even if people haven't got annual leave booked, that they take some of their annual leave during the current period, whether that's whether they're furloughed or not, just to try and make sure that people are using up their annual leave. And others, though, being more flexible about it. And we have seen, we haven't talked about it, but the government's introduced a change to the working time regulations, which will allow people to carry forward any untaken annual leave entitlement over the next 2 annual leave years where they haven't been able to take it because of coronavirus. So that gives employers a bit more flexibility as well.
Yeah. Okay, literally last couple of questions now. So when you've started a redundancy consultation but you've not closed the process yet, should you pause?
Good question. I think it depends on whether your business case for the redundancy still stacks up. If your redundancies were completely unrelated to coronavirus and you've still got a redundancy situation, there's no obligation to pause. If though you're not sure and things have have changed as a result of the current situation, we've got some businesses that are booming as a result of coronavirus. Supermarkets are run off their feet and desperate for staff rather. So in those situations, then you should pause because your business case for the redundancies no longer exists. So I think it depends.
Okay, last question, and this is quite a contentious issue because I've seen a lot of chat about this in some of the HR groups, and it goes back to the point that we were talking about before, so maybe about childcare issues or, I suppose the strict guidance is that, the furlough is there to stop people being made redundant because of coronavirus. So, when we talk about furloughing staff because of childcare and things like that, there are some that are quite staunchly believe that you shouldn't use furlough for that sort of cause. A comment here sort of saying the scheme's about availability of work. It's difficult to see how a worker with work available can furlough someone who can't perform their duties.
Well, I think it depends on the reason that they're not able to come to work. And, also you've got to look at, are you inadvertently discriminating in those circumstances? It's not, if the employee hasn't got childcare, it's not their fault. And there's a lot of people that are adversely affected by the, by schools being closed, by social distancing restrictions. There's also a lot of variation in different roles, even with people who can do their work from home, it's not so, if you've got kids at home, obviously, you're not, necessarily able, depends on the age of the kids as well, not necessarily able to do a full 9 to 5 day in the same way that you would do in the office. So I think there's a lot of variation there. As I say, it's not clear in the guidance on this, but I think, the scheme does read very broadly, and it's not just about would they otherwise be redundant. And I think if you look at the situation where if somebody was, in normal circumstances, if you had someone who, couldn't come to work because of a restriction at home, you'd be looking at potentially a conduct or a capability dismissal if someone's not coming to work. And the reason they're not coming to work is because of social distancing restrictions and schools closing because of coronavirus. So I think that potentially falls within the scheme.
And then from a lawyer's point of view, because obviously it's one thing chatting about it as a HR level, but obviously, different when you're talking to lawyers because obviously they deal with this stuff day in, day out. Do you think that, if someone was said that they couldn't be furloughed because they have childcare, you could sort of potentially that could be discriminatory. We could see cases coming out of that if that's the only reason. That people are saying, "Well, I'm not furloughing you." Because I know I've seen some comments about people trying to rearrange staff to, if there's a reduced amount of work, to give that to the people that perhaps haven't got kids or whatever, and then furlough the ones that have.
Yeah, I think you've got to be careful to be objective about how you're doing it. So I think it's, if you've got a situation where you've got some work, but you need to furlough some of the employees, then factoring in those who might be at risk because of underlying health conditions or who are going to struggle because they've got childcare responsibilities or other caring responsibilities, those are potentially relevant factors. I don't think any of them should be absolute though. It would be potentially disability discrimination if you automatically furloughed anybody with an underlying health condition who didn't want to be furloughed, or similarly if you made the assumption that anyone who works part-time has got childcare responsibilities, so they're going to be furloughed. That's potentially indirect sex discrimination. It is still the case that the majority, and we're talking about trends, it's not every household obviously, but the majority of caring responsibilities are undertaken by women. So that's still that the statistics still back that up. So I think you've got to be careful about not using any of those as automatic selection criteria. But if you've got someone who's struggling and was quite happy to agree to be furloughed in those circumstances, then fine.
Okay, I know you've got to shoot, so thank you so much for today. I hope it's helped everybody that's on the call. There will be a recording in the group for anybody that wants to have a replay or remind themselves of the advice that's been given. And just thank you, Nicola, for joining us today.
My pleasure. Stay well, everybody.
All right, thanks everyone. Take care. Bye.
Bye.